Hi everyone, I'm Hajdi Biuk. I'm a lawyer in NGO Sunce. I'm here to represent you the legal framework for solving pollution problems in the former Ferroalloy factory in Dugi Rat. I will do a representation of the process of the remediation and the current situation from the legal perspective. So for the remediation of environmental damage, that is the case in Dugi Rat, the directive on environmental liability is applicable. And the directive is applying to environmental damage, but also to imminent threat of such damage. And it is applied to all the activities under the directive, which are mostly surrounded around industry. The directive principle is, the reason for this directive is to enforce the polluter pays principle, to ensure that the operator who did the damage is the one that will actually remediate it and cover the cost of the remediation. The point is to create an environment which no longer possesses any significant risk of affecting human health. So since the industry is mostly being done on the land is one of the components of the environment that suffers the most. So the regulations that are used in these situations are mostly land regulations. But unfortunately, neither Croatia, neither European Union has sufficient land regulations, which is a problem in situations like this. So this is a timeline of the remediation of ground area. First, in 2009, the factory was demolished. After that, there was a first study. In that study, the material should partly be treated as a mineral raw material and partly as a waste. The inspection did the intervention, and they decided in 2011 that the operator was doing illegal acts with exploiting the material and using the material but not processing it or deposing it the right way. And it did it without the permits. So there was one remediation program in between in 2014, but it was not legally right. So the new program and the last program was in 2015. And the deadline for this remediation program was 2020, but it haven't been conducted. After 2020, the responsibility under the Environmental Protection Act falls on the ministry. So it is the authority to conduct the remediation again, but they can again choose a new operator that can do the remediation. Now the situation is that the ministry is conducting preparatory actions. We don't have enough information of what are those preparatory actions, even though we asked, but probably they're choosing a new operator or defining with the last operator how it will be done, because the last remediation program is not valid anymore, so the new remediation program has to be done. So this is the legal framework in Croatia. Of course, it's not all, and this is the basic. Environmental Protection Act, Regulation on Liability for Environmental Damage, Regulation on Environmental Remediation Measures and Remediation Program, Regulation on the Protection of Agricultural Land against Pollution, as I said, because we don't have a land use regulation, and in that case we can use the regulation of on agricultural land, which is not very. It's different. The agricultural land, the rules are different and the standards are different, and of course that the materials are not they're not complied with this regulation, as it is more stricter. Regulations on the abolition of the state of waste. That's the topic that Ivana covered around. Abolition of status of waste and creating the byproducts of the former waste. So the bolded ones are actually I would say, the biggest problems in remediating the land. First, insufficient soil protection regulations. Secondly, property relations on the land. The state and Projekt Uvala, which is a company that was the operator by now. I'm not sure if it will continue to be. They are fighting, or they're still negotiating around the land, because part of the land is the ownership of Projekt Uvala, but other part of the land is from the state. Meanwhile, the municipality of Dugi Rat is also trying to buy the land, have the land for themselves, because that way they can conduct and choose the operator and choose the project for the remediation. But the mayor could say more about the process in which that is. Part of the land is maritime domain, which falls under special rules and has to be managed by the concession. Settlement on the sale of the land, I put the question mark because I'm not sure if the settlement has been made, but the municipality, as I said, and the citizens are against the settlement of selling the land to the operator, as it has been a long time since it has to be remediated, and they didn't do it. Third, there are even criminal accusations around the company, and because the polluting the environment is also a criminal act. So why am I talking about this? I will do a quick explanation. The citizens approached us via Green Phone service, which is a free available service for all the citizens which have some environmental problems to contact us, so we can give them advice or even conduct some actions on ourselves. They were complaining about black dust, indications of respiratory problems with reproductory system. It is all, they're all indication, there is no science behind it, but they're afraid that the material is being carried with the wind and polluting their and affecting their health. So in 2021, Sunce informed Ministry and the State Inspectorate about the situation, and even though based on the sanation program, the State Inspectorate should have been doing the inspections, I don't know, I think a few times a year or less, I'm not sure, and then provide the report to the Ministry. No such documents were presented, and it seems like nothing has been happening for all 4 years. The Ministry was acting like they first time acknowledged the situation. Protests were organized by Citizens Initiative for Dugi Rat, mostly because they are against selling the state property to operator, because they are afraid that the operator won't conduct the remediation properly and that they can do more environmental damage. Sunce also requested for the inclusion in remediation procedure as interested party, that it was somehow testing the law. We knew that we don't have that right strictly by the law, but they could have given us that law under the Aarhus Convention that is governing the participation of citizens and NGOs in environmental matters. So a request is denied, as we were assuming, and this year Sunce filed a class action against the ministry. It is a lawsuit in a civil law domain with which we are trying to protect the citizens, the rights of the citizens of the area, and somehow to impact the ministry to do the remediation as promptly and as efficiently as possible. That is also a pioneer lawsuit that has never been made in Croatia, and we are also testing the law and seeing how the things are going to go. This is a video that the citizens showed us. So further you can see how the material is being carried away with the wind. And they also have a lot of black dust on their balconies, which is why they're so scared of the effects on their health. Okay, this is the last one, and thank you.